My name is Ravi. I'm from Armchair Criminal and I welcome you all to this part of the program. This is the second part of a six-part series on confessions. We considered or began to consider how self-confessions are dealt with in court. Although we didn't go into much detail, so therefore I will cover the remaining part here. Therefore, I pose the question at this stage: how does the courts deal with self-confessions when they are adduced? If the self-confession needs to be admitted in evidence, certainly the learned trial judge will give warnings to the jury. However, not all self-confessions will be admissible in evidence. There are very valid reasons for that. We will consider the case of Allen and the United Kingdom, which highlights the possible dangers and the difficulties in self-confessions. Self-confessions are generally admissible where the parties are on equal terms and where the self-confession has come without any inducement, pressure, or any oppression on the part of the Crown. This is specially scrutinized where the suspect has made no comment in the interview, or even for that matter has denied the allegation, and then makes self-confessions. Why self-confessions are dangerous and specially scrutinized by the judges is quite simple. Self-confessions take place by definition either in a police cell or in a prison cell. So the person who's going to give evidence against the defendant, by definition, must have been incarcerated at some point, either as a suspect or a defendant or a serving prisoner. Therefore, by definition, that person cannot be a man of impeccable character, or at least the suspicions are there that he or she is not an impeccable character. Therefore, when you have to rely on the words of such an individual, one may raise one's eyebrows as to the evidence that individual is to give evidence against the defendant, because that individual may have an axe to grind. For example, he or she may want to say things against the defendant, possibly with a view to getting a reduction in his or her sentence. So therefore, there could be a motive for that. Then also, we considered the kind of a person who's going to give evidence against the defendant, i.e. a person who is incarcerated. Therefore, the courts will consider, is this person is a reliable witness? Then thirdly, it may very well be that the person is quite genuine, even though accused of a crime, may be completely innocent and go to defense and not seeking to get a reduction in his or her sentence. But that witness may very well have misheard or misunderstood or misremembered what was said. So therefore there are problems in approaching self-confessions. The case of Alan and the United Kingdom. I got the authority here, and this was a case of robbery taking place, and there has been a murder. The police have gone to great extent to establish the case against the defendant, but has been unsuccessful. As some police officers would, very ambitious, go to great extent to secure conviction. What they had done is to put a person in to the cell, an informant, be with the defendant, and basically has said, push him for what you can. In other words, instructed the informant to push the defendant to get whatever he can. Okay? Then there came a point that certain admissions were made or confessions were made. The prosecution wanted to adduce that, and needless to say, the defendant didn't want. When he was convicted, the matter appealed, and the court did find that there has been a breach of Article 6, Article 8, human rights violations completely. And not only that, if I recall correctly, what the prosecution and the police have tried to do is to adduce evidence which was unavailable through the normal mechanisms of interview. So what they are trying to do is to bypass that mechanism. The court said no. So you can see how difficult, how dangerous things can be. I will read the relevant part from the judgment at H10G. In his interview with the police following his arrest, the appellant, on the advice of his solicitor, consently availed himself of his right to silence. The evidence adduced at trial showed that the police had coached the informant and instructed him to push him for what you can. The admissions allegedly made by the applicant to the informant, which formed the main or decisive evidence against him, were not spontaneous, unprompted statements volunteered by the applicant, but they were induced by the informant's persistent questioning at the instance of the police. This effectively amounted to interrogation without any of the safeguards which would attach to a formal police interview, including the attendance of a solicitor and issuing of the usual caution. In those circumstances, the information gained may be regarded as having been obtained in defiance of the will of the applicant, and its use at trial infringed his right to silence and privilege against self-incrimination. Accordingly, there has been, in this respect, a violation of Article 6. There you are. Not only that, remember, basically, as I said, what the police have done is circumvent the whole process by putting an informant, which is playing well below the belt, and that is not something our courts would entertain. Next, let's consider the point of when does the automatic exclusion of confessions apply. Confessions will be excluded where there is evidence of oppression or where it is unreliable. I would categorize the case of Allen within the scope of oppression and unreliable, because he didn't make them voluntarily, and there was basically trickery used by the police. That is fairly poor show on the part of the investigating team, because it was not voluntarily and basically taken as evidence through pressurizing the man. It could equally have been unreliable. We need to consider what is the statutory definition of oppression. This is defined in Section 76 of the Police and Criminal Evidence Act, in particular subsection 8. It is defined as, in this section, oppression includes torture, inhumane or degrading treatment, and the use or the threat of violence, whether amounting to torture. Remember the operative word, includes, so it is not limited to. What is oppression for one person could be different to another person. You imagine you get a hard-headed client who has a string of convictions, been to prison, been to police station and courts many a times, and well seasoned criminal. What could intimidate him would be very different to a young boy or a girl of say 14 years of age, never been in trouble before, completely accused of a fairly serious crime, worried whether he or she will get bail, will go home. Even when he or she goes home, what could be the consequences that he might face at home from his parents? So oppression could take place in many different forms, and it could be a point of relativity to the person and the circumstances. Therefore, be ready to argue looking at the person concerned. I have been in situations where one day I was at a police station, a young boy was arrested for a very minor offense of shoplifting. I went to the police station to defend a different client. This young boy's mother came. Custody sergeant the custody sergeant brought the young boy from the cell to meet his mother. Even before saying anything, the mother slapped the boy. So you can imagine what could be the consequences for that boy when he goes home. Therefore, is it proper to rely on any confession that the boy might make thereafter? I accept the police didn't do anything wrong. It was the mother who slapped the boy. But nonetheless, it did take place. But what was interesting, the custody sergeant sent the mother out and told me, I think justice has been done. I'm going to tell the police officers, come to a pretty quick decision and let the boy go home and call it a day, because he's going to get far more from the mother and the family than what the police can do for him. I thought that was pretty good summary judgment. Now, the next question that what I would pose is, what is the leading authority on the point and how the courts have interpreted? The leading authority, even at this stage, one would have thought is the case of Fulling. There the court said, give the natural meaning to the word oppression. And in deciding whether oppression is there, courts will look at, has there been any impropriety on the part of the investigating team? That is why when we looked at the case of Allen, I said that I would regard that as oppression. That is oppressive behavior. You imagine when a man is arrested and in custody, especially for a serious allegation like robbery, murder, rapes, kidnapping and the like. At that point in time, any individual will be very vulnerable, confused, worried. And then to manipulate and to use any oppressive, impropriety behavior would be oppressive. The next question that I would pose at this stage is, what is the difference between confessions obtained by way of oppression and unreliable evidence? The fundamental difference between a confession that is obtained by means of oppression and a confession obtained without oppression but unreliable is there is no impropriety when the evidence is just merely unreliable. Unreliability could come as part and parcel of oppression, that is why it is. But unreliability could exist in the absence of any oppression. How could that happen? To that extent, I ask myself the question, what could amount to unreliability? Unreliability could take place in various forms, and it is generally attributable to personal circumstances and characteristics of the suspect. What do I mean by that? In other words, the investigation team has nothing to do with this particular problem. It is an inherent problem. The facts of the case or the characteristics of the suspect. How could that happen? Well, it could be because of the suspect has low intelligence, low IQ, might have learning difficulties, might have ill health, may be so vulnerable that the suspect could be easily led, suggestible, and could be a compulsive mythomaniac, or the suspect could be suffering from shock. Equally, those things I would have thought are personal characteristics of the individual. Now, with regard to the circumstances of the case, it could be that the suspect is stone drunk, recovering from drug addiction, withdrawal symptoms, having taken drugs earlier, or could have suffered injuries. Then equally, there could be breaches of pace. We know that under Section 58 of PACE, every suspect has the right to legal advice, independent legal advice, at the expense of the state. Equally, under Section 77 of PACE, if I recall correctly, there's a definition of a vulnerable person, mentally handicapped. And those people are, those vulnerable people and juveniles are entitled to have an appropriate adult, possibly be seen by healthcare professionals to determine whether the person is fit to be interviewed, fit to be detained. If those things are not done, then there could be repercussions as to the reliability of the evidence. One of the things that we got to consider is how does the courts generally react if drink or drugs are involved. Now here, the courts generally take that into account, but not always, because there is a room for maneuver here. When one considers Section 76 subsection 2b, it reads things said or done by someone else. Remember the Section 76 definition? And when one considers Sections 76, for it to be unreliable, things either said or done by someone else. How could the courts be satisfied that self-induced intoxication is done by someone else? Consequently, the courts are at liberty to escape, if the court so desires, saying that the confession is unreliable. The next question that I would pose is, if the confession should be excluded under Section 76, subsection 2b, can the error be cured by getting the same confession to be repeated at a later stage? The answer will largely depend on whether the second confession was influenced by the first confession. I had a young client who was visited by the police for a very serious allegation, and my client was asked one question. That's all. One question. By repeating the allegation, asked, did you do it, basically? The answer was some of it. Remember, this was at home, so there was no solicitor, and this is a young child. Not only young child, he suffered from low IQ and learning disabilities. His mother was there, so there was an appropriate adult. But there was a problem. The mother doesn't speak English, or not very well. So in effect, there was no appropriate adult. The police officer very promptly wrote it down on his notebook and got the client to sign. Went to the police station. He repeated the same thing in the presence of the custody sergeant. Got the mother and the son to sign the custody record to that effect. He was legally represented by someone at the police station, following which he was charged, and I represented him at trial. Now I had the whole passage excluded because there were breaches of peace, and the fact that my client got mental health issues, low IQ, learning disabilities, depression, therefore unreliable. Now, the case of McGovern is a case that dealt with the same issue, basically, where this was a case. Yes, this is literally on the point. In fact, confessions were secured and then proceeded to have another interview. At trial, the court was invited to exclude the evidence on appeal. The court said, we are of the view that earlier breaches of the Act and of the code renders the contents of the second interview inadmissible also. So, if the second interview was influenced as a result of the first interview, then the second interview will also go out. In order to discharge the responsibility of establishing that the interview was properly conducted or not, who bears the legal burden? The answer is quite easy. It is the Crown who's bringing this case. It is for them to establish it. It will be wrong for the defense to be expected to do the bidding. No. It is they who want to introduce. Let them prove the case. Because Section 76 subsection 2 is quite sure of that. It says, insofar as the prosecution proves to the court beyond reasonable doubt that the confession, notwithstanding, in other words, it is they who have to prove what is to be adduced. Leading on from that, let's ask ourselves the question, can the courts receive evidence? In other words, can the prosecution rely on Section 114 to introduce a confession that is excluded under Section 76, subsection 2A, B, or B? Now, in a previous recording, I said Section 114 can be used to adduce a confession. You might think, now I'm making a contradiction when I say the short answer is no. because section 128 of the Criminal Justice Act states, subject to subsection 1, nothing in this chapter makes a confession by a defendant admissible if it would not be admissible under section 76 of base. So this goes right against what I said earlier, some time ago. How do I justify that it is possible? Yes, here the section 76 and section 128 refers to confessions that is made at police stations or outside the courtroom. There I referred to section 148, where the defendant, now remember the phrase has changed from suspect to the defendant, i.e. charged, and appears in court and gives evidence under oath. Now we go for a retrial. Any admissions made during that trial might be admissible under section 114. That is why I said previously you can. So you look at the two situations. If it is a confession at a police station or pre-charge or even post-charge but not during the trial, then section 76 would play a part. But the moment he takes the oath and gives evidence in the front of a judge, represented by counsel, and goes for a retrial, it will be foolhardy to say that it can't be adduced because it's a confession caught by section 76. Remember, the purpose of section 76 is not to give a blank check to the defendant. You can say anything so long as you are not very well, we will exclude it every time. No. It is there to see that is it unreliable. Here the problem will be the defendant will find it almost impossible to say it is unreliable because there was a judge who's presiding over the matter, ensuring that the playing field is level for both sides. The defendant would be represented by counsel. There's a judge and jury. Everything is, all the safety procedures are there. And there could have been mental health reports and the like. So therefore it will be foolhardy for us to give a blank check to the defendant to say that will not be admitted under section 114. That is what I meant, that it is possible, but you got to look at the circumstances. Now we talked about unreliability. The next question that I would pose is, where are the safeguards for mentally handicapped suspects? Remember, as I said, we are looking at suspects, not the scenario that I gave earlier, where the defendant has given evidence. Okay. Here you look to section 76 of base and code C. Code C determines and is there to safeguard the interest of those who are in custody. Section 76 defines mentally handicapped. So the question is, what is the meaning of mentally handicapped? Section 76 defines this. Mentally handicapped in relation to a person means that he is in a state of arrest or incomplete development of mind, which includes significant impairment of intelligence and social functioning. What you would note is it's a fairly broad definition. The list goes on. Next question that I would pose is, what are the safeguards available? So we know the definition. Now let's look at what are the safeguards and how do we do this. It is quite easy. When one considers the difficulties the court has and what can be done. One of the things that we must remember, whether the person is a complainant, an independent witness, a police officer, or the defendant, we treat everybody the same as witnesses. Therefore, there is nothing to ask for safeguarding procedures to be adopted for the defendant to give evidence. At police station, there are safeguards too. Should be seen by medical practitioner. Find out whether the person is fit to be detained, fit to be interviewed, fit to be charged. Possibly, outreach team will come and assess the person for mental health issues, and if there are any concerns and is fit to be detained, fit to be interviewed, fit to be charged, would recommend generally an appropriate adult. So these are the safeguards. What the lawyers would do in those circumstances where there are concerns, first of all, the lawyer should seek to exclude the interview or the relevant admission, the confession, like I did with my young client on that occasion. If not, the judge would warn the jury, acting on the words of confession by a vulnerable person. Equally, if the trial is conducted before the magistrates or a district judge, as lawyers, we should and we could remind the court to exercise special caution in dealing with such circumstances. The next question that should be posed is, how does the Court of Appeal has dealt with? In other words, what are the guidelines from the Court of Appeal? There's an authority by the name of Mackenzie. Mackenzie is a case where the appellant was convicted of serious allegations of arson, manslaughter. In fact, two allegations of murder. And he was under investigation for another murder. There, some interviews took place in the presence of the solicitor, some didn't. And it was apparent that he suffered from mental health issues. The prosecution wanted to adduce and did adduce the evidence of the confessions at trial. He was convicted and later he appealed. What transpired was that he has admitted to several murders that he was not even responsible for. This is a guy who goes around putting his hands up for anything and everything that the police might put to him. It could be for the reasons that we discussed earlier as to why confessions could be unreliable, or it could be that seeking notoriety. But whatever it is, it was obvious that he is admitting to offenses that he did not commit. So much so, for the Court of Appeal hearing, the defense instructed expert witnesses And one of the expert witnesses said that parts that he cannot remember could be because of insomnia, but ruled that out as a possibility, because even for the 2 murders that he got tried for, there were patches of evidence which did not match with what has happened. So he could have learned at least some facts from newspapers and the media and what was discussed in the local community. Then there's also the scenario where he is admitting to offenses that he possibly could not have committed. To make things even more interesting, the psychologist gave him a scenario of a murder, a fictitious murder, which has not taken place at all, let alone it something has taken place, the police are investigating. This is completely out of a storybook. And he admitted to that too. Taking all that into account, the Court of Appeal said basically where the case against the defendant is wholly or substantially depends on confessions, and he suffers from mental health issues to such a degree that he is basically handicapped, and where the evidence is so unconvincing that a properly directed jury cannot convict him, the judge had withdraw the case from the jury unless the evidence has already been excluded. Therefore, the judge also has a responsibility even if no application is made by the defense, because the learned judge has the power under the Galbraith test to stop the trial and dismiss the allegation. That is all I propose to say at this stage of the part 2. And for that point that I discussed just now, is the authority is Crown and Mackenzie. And we will move on to part 3 very soon. Thank you for your valuable time. I hope you found this part of the program useful and enjoyed it. God bless.